So thank you so much for joining me this evening. We have Greer Donley, David Cohen, and Rachel Rebouché here to talk about the pair of cases that we all have been paying attention to for some of us more than a year now, but pretty much everybody in the country for the past year since Judge Matthew Kaczmarek first announced he was going to hold a closed hearing on a case over a challenge to the 2000 approval of Mifepristone and the subsequent loosening of restrictions on that drug. We are now a year forward, and the oral arguments are coming up at the Supreme Court at the end of March, and all attention will be on the Supreme Court. But we are lucky enough to have the three of you who have been writing about and telling everybody about what we need to be worried about in this field for a long time, and everybody's been listening at least for the past 2.5 years. And so I guess just to start us off, this drug was initially approved in 2000. How did we get here?
Well, I mean, I think that we've seen a huge politicization of science, obviously, over the last few years. So, some of this has to do with cultural changes, I think, that we've seen for a long time, but that really have been going on in the anti-abortion movement for decades and longer than that. So, the three of us wrote in our abortion pills paper that abortion pills were going to be this huge focus because they were radically changing how abortion was accessed and allowing people to get access to abortion even when their state banned abortion in its borders. And so that put a huge target, I think, on medication abortion and allowed kind of the anti-abortion movement to take advantage of some of the cultural things that were going on and to really, attack this medication, which has been approved since 2000 and is one of the safest and most effective drugs on the market.
And so we had this case brought, and obviously it was brought by Alliance Defending Freedom, representing these sort of brand new organization that happened to appear in the Northern District of Texas, the Alliance for Hippocratic Medicine. And the case, because of that, went before Judge Matthew Kaczmarek, who has been a choice judge to file cases in front of because he's in a single judge division. Although on March 12th, the rules surrounding how cases are going to be handled going forward have changed, and so this sort of forum shopping might be a little different going forward. But can you walk us through what the impact of this case having started with Matt Kaczmarek has done?
Yeah, strategically choosing to file a case where they did, knowing that they would get Judge Kaczmarek, who has a long history of being a part of the anti-abortion movement, being a part of the anti-LGBTQ movement. He really comes from that background. And everyone knew it. I mean, that was part of his confirmation hearings, and he was confirmed anyway. So they knew they were going to get the most favorable forum possible for this claim. And he has delivered. I mean, he has, with initially, like you said, wanted to have a closed door hearing, and then ultimately it was not. There were reporters there. But then what he delivered was, he basically agreed with every claim that the Alliance for Hippocratic Medicine made. He said they had standing. He said they could challenge this approval from 23 years ago. So no statute of limitations problem. And he said the approval was unlawful, the changes were unlawful. And so they got everything they wanted from him. And then the emergency appeal to the Fifth Circuit modified it a little. But it's sort of, I like to call it a cheat code. Until today, interestingly, to file it before a judge that is going to rule in a conservative fashion, and then have the appellate court be the Fifth Circuit, which is a very conservative court. It's a way to game the system, and they were able to do that with this case. And surprisingly, I think to some of us, the U.S. Supreme Court issued a stay that has lasted until now and for a few more months. But there's the potential to have the Fifth Circuit ruling come back into effect.
And under the Fifth Circuit ruling, basically, they pulled back this part of Kaczmarek's ruling that would have gotten rid of the 2000 approval, but he kept in place the Kaczmarek's ruling. The Fifth Circuit kept in place Kaczmarek's ruling as to both the 2016 and 2021 loosening of restrictions. Rachel, what would that do if that part of the ruling even was upheld?
So I think it would have varying consequences, but I do think it's worth noting that even the Fifth Circuit was ambivalent about the 2000 approval, and the Supreme Court was uniformly against reviewing a decision of the FDA from now 24 years ago. And, there's something there to really, I think, consider about where the Supreme Court is, because I believe that rolling back the regulations to before 2016 would be an affront to science and research and all the things that have happened in the years that have all the things in the last 10 years that have showed us that medication abortion is safe through 10 weeks, it's safe through the first trimester. Medication abortion does not need follow-up visits. It does not need to be delivered in person. But as my co-authors know, I think that the real crux of this litigation is the in-person pickup restriction that was repealed in 2021.
Right.
And that is what really is being litigated, because that, I think, as we argue in our paper, is the thing, this linchpin that liberates medication abortion in a way that is very hard to control.
And we've mentioned now this Supreme Court ruling last April that essentially froze the law to the current status while this litigation is going on. What did that tell us? Did that, I mean, do the tradition? It seems like the traditional rules about likelihood of success are sort of just a juggling ball in the air right now. Do any of you think that it told us anything significant?
I do, because I think that Alito opened the door for that in the majority opinion. In that last paragraph in the majority decision, where he says anything goes, any state interest is a valid state interest in restricting and regulating abortion, earliest moment of pregnancy, against discrimination, on the behalf of the unborn fetus, on the, to restrict procedures. He essentially announced, like, states, anything you want to do, it's open. And now we're seeing litigation that's unfolding, not just in this context,
right,
but for EMTALA, for, exceptions, because the Supreme Court did not put any safeguards, they had no guardrails of what would be the implementation of Dobbs, that would be something that was measurable and
Right.
incremental. It forecasted what we're seeing now as the legal landscape and the chaos that we're in.
Now we're at the Supreme Court. We've got these arguments coming up. The briefs really focus in on the standing question, whether the 2016 and 2020 and 2021 actions were arbitrary and capricious, whether the remedy was proper at this preliminary stage, and whether the consideration at all was appropriate in light of the incomplete administrative record. Now, all three of you submitted amicus briefs in the case, or were part of amicus briefs. David and Rachel, yours focuses on the standing dispute in particular, focusing on both causation and redressability. Can one or both of you, each one of you can pick one and one the other, can talk to us about what it is that you were telling the court?
So much has been made in this case about the fact that there's no, so standing requires three things: injury, causation, and redressability. Every plaintiff going into federal court needs to have all three of those things. A lot of this litigation has been focused on whether the Alliance for Hippocratic Medicine has been injured, because they're really talking about something that might happen in the future, that their doctors may treat a patient who has some kind of post-medication abortion desire to go get treatment, not even a complication, just they feel they need to be seen. And so that's hypothetical. It's in the future. The fact, the possibility of any one of their doctors as opposed to any of the other doctors in the country, it's very tangentially related or likely to happen. So it's focused on injury, and that's been much of the litigation. Our amicus brief focused on the other two requirements of standing, because they have been not as much as central to the litigation, but we think they're also flawed. And so on causation, they're suing the FDA. And so the FDA approves the drug and puts in strict place the restrictions. The FDA doesn't cause doctors to prescribe it to any particular patient. The FDA does not cause any particular patient to choose medication abortion over procedural abortion. The FDA does not cause patients who receive medication abortion to say they need follow-up care. And the FDA does not cause them to then go to any particular doctor, part of Alliance for Hippocratic Medicine, as opposed to the doctor who prescribed it, or the other medical care professional, or their own healthcare professional they have a relationship with. So there's such a long chain of causation between the defendant, which is the FDA, and the claimed injury, that we argue that that's not sufficient under longstanding Article 3 jurisprudence from the Supreme Court about standing. So that's the causation argument.
And I also, I want to bring in Greer's amazing brief on, that she wrote with colleagues, but, she has been a mastermind of really calling out the Kaczmarek decision and the Fifth Circuit for misunderstanding what the FDA can actually do. Like, what are their powers in the wake of a decision, and what happens next? There's been a lot of popular press that with Kaczmarek and the Fifth Circuit, were they to go into effect, like the FDA would just overnight change, and that's not how the FDA works. So, I'd invite Greer to talk.
Oh yeah, I definitely want to talk about that brief. It was very notable. What about redressability, though?
Oh yeah, so the redressability point is that part of the court's record, and what we know, is that abortion providers in this country are planning, if Mifepristone is now restricted in a way that doesn't work with how they want to prescribe it, they are planning, and this was part of the record, to switch to a misoprostol only regimen. Misoprostol is the second drug in the regimen that's approved in the United States, but it is not being challenged in this case because it's an ulcer medicine that's used off-label for abortion, and it is an approved abortion drug on its own around the world by the World Health Organization. The American College of Obstetricians and Gynecologists approve misoprostol alone as a form of abortion. Whatever happens in this case, misoprostol will remain available. It can be mailed, it can be prescribed by non-doctors, and it is much cheaper and much easier to access. There are none of the restrictions. And so if abortion providers switch to misoprostol, which is a very likely outcome if mifepristone is restricted, then the same injuries, maybe even more, because misoprostol leads to more cramping and bleeding and nausea. The same injuries or more would happen, and you need to show, in order to get into court, that the remedy you want will likely redress your injury, and we don't think that that's true here.
And yeah, Greer, your the Food and Drug Law Scholars Brief. I thought it was really interesting by focusing. It was both like a in the nitty gritty brief and like big picture what we need to be paying attention to brief, because it focused both on the specifics of these 2016 and 2021 changes and why they should be respected, but also the larger implications for both the FDA and public health if this challenge succeeds. Can you talk through a little bit about like why and how this brief came together and what you think is most important about it?
Yeah, it came together really, my colleague Patty Zettler and I, the second the case was filed, this case was filed in the district court, we were, she's a FDA law scholar, and we were texting about it, and we roped in another colleague and got a law firm to help us write it, and that's kind of how it all happened. But you know, the brief really tries to make the point that this is actually like a extremely simple case from FDA law perspective, right? In some ways, we've gotten lost a little bit, right? It feels like we're debating about science, and it's, you know, hard to debate about science when you're not a scientist. But the truth is, if you just look at the, you know, the standards that that Congress really, you know, in their statutes said that FDA had to use when they made changes to a drug, right? So we're in the land of really evaluating the changes that FDA has made, and there's two different types. And I'm going to try not to get into the nitty gritty, but one is removing REMS elements, and one is adjusting the label. And Congress has made it pretty clear what's required when you adjust the label. You have to have one clinical trial, essentially. I'm paraphrasing, right? In this instance, there were some, you know, depending on, you know, the part of that they were, when they were adjusting the dosing, for instance, they had 22 clinical trials, right? So we're talking about just like so much more information than it was necessary. But even more importantly, for removing REMS, there's no clinical trial requirement at all, right? So the Fifth Circuit made this huge point about how there was no, you know, one clinical trial that evaluated
Did everything, yeah,
all at once in one fell swoop, as if there needed to be a clinical trial at all. Right. And they reviewed clinical trial evidence that combined multiple factors into different, like the evidence here is so unbelievably overwhelming. So we try to really make that nitty gritty point clear by going through the statute, going through the evidence that was before the agency. And then we try to say, you know, if the court were to say, you know, that this wasn't good enough, this is going to have huge implications for pharmaceutical innovation more broadly, because, you know, guess what? You know, what's good for the goose is good for the gander. Here, there's going to be all sorts of other drugs that are going to come under fire. You know, again, we started the call talking about the politicization of science. So What about gender affirming care? What about contraceptives? There's going to be all sorts of incentives to try to go after different types of controversial drugs. And all of a sudden, there's a standard that seems to, the courts are basically requiring more than Congress required by a significant amount.
And also, what about vaccines? What about mental health care drugs? What about, like, fill in the blank? Any drug that some other company has a reason to contest and pro-offer their own evidence, no matter how, in the minority it is, for the evidence of efficacy and safety. I think it really does relate to redressability, in that there's so much science on the side of why medication abortion works. MISO alone, or Miffy with MISO, like, there's any number of reasons why we think the FDA would say, yeah, this is not a problem that we need to address. We're going to use our enforcement discretion. So that's another standing point, that the FDA does not have to act in response to this quote unquote problem, because it's not actually a problem.
So when the arguments begin, and we're looking at the justices hearing this case on March 26th, what are what's the I'll do a round robin. What's the top thing that you're going to be watching for?
Well, I am afraid that we're all going to say the same thing. So
well, you can go first, Greer. You win.
It's not fair. It's not fair. So, okay, well, Dave and Rachel, raise your hand if you're going to say Comstock. Well, yeah. So I mean, I think that we're all very hyper focused on whether that comes into account and how the court is thinking about it.
So how was, I mean, so you all, I mean, most recently at Slate, wrote this op-ed about how Joe Biden should have raised the Comstock Act in the State of the Union address, and how it's raised in this case, and it likely would be a big part of efforts to cause further reproductive rights restrictions should an abortion restriction should a second Trump administration come into play. So first, I guess, how is that in effect here in this case?
So part of the claim from the Alliance for Hippocratic Medicine is that the FDA did not appropriately approve mailing abortion pills in the 2021 change that we were talking about, because there's a law on the books that prohibits mailing anything that produces an abortion. That's the Comstock Act. It was written in 1873. It has been, slightly changed over the years, but it has this provision which says that you cannot use the mail or any kind of express mail service to mail anything that can produce an abortion. And so the argument from the Alliance for Hippocratic Medicine is that, on top of the arguments we've been talking about, that the science doesn't back the abortion, that Mifepristone and the other changes, they're also saying that the FDA could not lawfully have approved mailing abortion pills because Comstock prohibits doing so. The challenge here for them is that for almost 100 years, circuit courts, not the Supreme Court, because it's never gotten to the Supreme Court, but circuit courts have said, dating back to the 20s and 30s, that the Comstock Act only applies to unlawful abortion. And in 2022, right before New Year's 2023, the Biden administration's Department of Justice wrote a memo explaining that that is the correct interpretation and their understanding of the Comstock Act. So basically, it only applies to unlawful abortion. So it wouldn't change anything with respect to mailing pills. But the anti-abortion movement right now is saying, well, the word unlawful is not in the text, which it isn't. It's not like we disagree about what's in the text. The text is the text. It's not in the text. So they say that that's an incorrect interpretation. It bans mailing all abortion pills. And so that should be another reason why the FDA acted inappropriately here. The risk is that if this interpretation gets adopted by the Supreme Court, it could have ramifications beyond pills, because the law does not just say drugs to produce an abortion, anything to produce an abortion. And so that would mean supplies and equipment that are used in abortion clinics for procedural abortions. They're also, it's not like they grow them in their backyard and then just transport them from the backyard to the clinic, right? They get them through delivery services like the US Postal Service and FedEx, UPS, etc. And so if they can't deliver those for them, then how is any abortion clinic anywhere going to operate? It's going to basically shut down abortion. And thankfully, there are people on the anti-abortion side who are being very explicit, making this argument now. Jonathan Mitchell, Mark Lee Dixon, the Heritage Foundation, they are making this argument, and they're saying that Comstock in effect can be a nationwide abortion ban if interpreted the way they think is correct. And so getting back to your question, why we're so focused on this, if the Supreme Court, if the justices are interested in Comstock, it's going to be scary to see how they think it should be interpreted and what that might mean in 8 months if we, or 10 months if we have a change in administration.
Rachel, is there anything else that you're going to be particularly focused on?
So and David and Greer have to forgive me for saying this, but as I mentioned earlier, I think that the Supreme Court is going to be laser-like focused on the in-person pickup reversal of the RIMS. I think that is the easiest thing to target. I don't think it's right to target it, but I think that is it. If you think about going in a time machine and making the country go back to 2015 for abortion access, where it's 7 weeks, not 10 weeks, it's, and all those things can be, not all of them, but some of them can be undone from off-label prescription and the like, but not all of them. So I'm not saying that would be an easy lift. It's really, I think, male medication abortion that is the threat to the post-Dobbs reality that the majority of the Supreme Court had in mind. When they returned abortion to the states, I think they truly thought that there would be this clean-cut set of policies of like, abortion's not legal in Texas. It's not legal in Alabama. Maybe it's in Massachusetts. I don't think they contended with the fact that the anti-abortion movement doesn't want to just stop abortion in Texas. It wants to stop it everywhere. And Texas was never going to just be satisfied with applying a law and then dealing with the messy thing that happens when you apply a law that's really badly written.
Right.
I don't think that I think that I truly believe that the Supreme Court believed, or at least Justice Alito believed in writing for the majority, that he was doing something that was more workable for the country. But as we've argued in many places,
before and after,
ferociously, that there's nothing workable about this. And so the thing that makes this truly unworkable is male medication abortion. And to stop that, I think, is the impetus for this litigation. That's my opinion. So I am watching for the Supreme Court to shut down virtual clinics, telehealth for abortion, and the ability for online pharmacies to mail abortion pills across the country. Because, we've already seen the proliferation of pills.
Right.
And I think that's what they're going to be focused on.
And just to set one piece of context, Chris, the the most recent data we have is from 2020, showing that 53% of abortions are through medication abortion. That's before the pandemic. Sorry about some background noise. That's before the pandemic, where people became more familiar with telehealth. That's before the changes in the REMS in 2021 that eased the restrictions. So it is very likely that we're approaching 65, 70% of abortions that are medication abortion. And so the risk with any of these restrictions being reimposed is that we're taking away or seriously cutting into a form of abortion that, is close to 2/3, maybe even 3/4 of abortions in this country.
Thank you so much for all of that.